Hello, my name is Alicia. My other group members are Matthew and Alexis. Today we are going to be talking about the Healthcare Consent Act and the social issues it addresses. The Healthcare Consent Act states unequally that a person with mental capacity has the right to agree or refuse treatment. This means that a patient must be able to comprehend and accept the implications of their treatment decisions. The Healthcare Consent Act was enacted in Ontario in 1996 and governs the competency to consent to medical treatment. The Healthcare Consent Act was used to replace the Consent to Treatment Act on March 29, 1996. This caused the Advocacy, Consent, and Substitution Decisions Statute Law Amendment Act to become effective. During this time, the Substitute Decisions was reviewed and the Advocacy Act was scrapped. The Healthcare Consent Act was brought in to prevent abandonment from occurring. It also provides the means to facilitate the mandatory admission, treatment, and the support of those who are incapable of making decisions on their own. The Healthcare Consent Act contains treatment-informed guidelines, admission to care institutions for those who lack decision-making capacity, substitute decision-making capacity and responsibilities. The Healthcare Consent Act addresses social issues that are decision-making capacity, ableism, exclusion, and stigma. Thank you.
Who is the policy for? The Healthcare Consent Act affects anyone who is receiving treatment, who is being admitted to a care facility, or who is receiving personal assistance services. The Healthcare Consent Act outlines the standards healthcare providers must follow in order to obtain informed consent from their clients. The Healthcare Consent Act also covers the procedures that must be followed by healthcare providers in order to determine if someone is capable of giving informed consent. If a person is found to be incapable of giving informed consent, the Act also outlines a hierarchy of substitute decision makers that must be consulted on their behalf. The Act also makes provisions for clients who have been deemed incapable of giving consent to seek recourse through a Consent and Capacity Review Board. Is the policy effective? The Healthcare Consent Act has been implemented with mixed results. While it does an excellent job at raising the issue of informed consent, the issue of substitute decision makers is controversial. The emergency clause gives the person prescribing treatment the right to assess the severity of a person's mental illness. If the person's mental illness is determined to be severe enough, treatment can be started against their will. This is a conflict of interest. When treatment is made without consent in an emergency, the treatment is supposed to be made in the best interests of the client. While the Act outlines principles for what this is, again, the person who is determining what the best interests of the client is the same person who is recommending the treatment. This is also a conflict of interest. An example of this is the case of Starson versus Swayze in the Supreme Court of Canada. Starson is a man who is refusing pharmaceutical treatment that was being forced on him even after he had had his case reviewed by a Consent and Capacity Review Board. The review board had determined that Starson was incapable of giving consent, as he refused to acknowledge that he had a mental illness, and that treatment would be in his best interests. The Supreme Court determined that while Starson denied the label of his mental illness, he did not deny the symptoms that he experienced, and was therefore capable of giving informed consent. The Supreme Court also determined that the proposed treatment for Starson could not be proven to be effective for his condition, and that Starson's complaint of a reduction of cognitive ability as a result of this treatment was valid grounds for him to refuse it. Finally, the Supreme Court determined that the review board had no right to assess what was in Starson's best interest, and that the board's only responsibility was to evaluate his capacity to give informed consent. The court ruled 6-3 in favor of Starson.
The Healthcare Consent Act is crucial since this means healthcare providers are not allowed to start treating you however they see fit if you're of sound mind and body. Informed consent must be obtained to begin treatment. A very important thing to note is that it is essential for the protection of both the healthcare practitioners and clients. If this act did not exist, healthcare practitioners would have the ability to treat people without even asking if the person is okay with the treatment. This also means that if a person is of sound mind and body, they are also able to refuse treatment, which is equally as important. This act is important because healthcare delivered without informed consent can cause serious harm. Testimonial that we wanted to include as a group was an incident that happened to a person that I personally have known for years. His mom was experiencing some health problems and went to the hospital in Toronto to get medical attention. When she got there, the doctors got her consent to start treatment for a lung issue, but did not set her up on a machine and left her in the hallway unmonitored. She was laying down and choked on her own fluids. When they realized, they revived her, but she no longer had any brain function and unfortunately passed away. This is an example of a case where consent was obtained, but it was not informed consent as the nature of the treatment changed significantly and impacted the quality of care. Thank you for listening to our presentation on the Healthcare Consent Act. I hope you have learned a bit more about this important piece of legislation.